Good morning, students. Today I'm going to start with the new chapter, the Indian Contract Act 1872. I hope yet everyone have viewed the syllabus, that what topics we have to deal under business legislation and industrial relation. Under the business legislation part, you have to learn three chapters. One is Indian Contract Act 1872, another is the Sale of Goods Act 1930, and the third one is the Negotiable Instrument Act 1881. These three chapters you have to deal, and the some part of partnership act like law of agency is also mentioned, which we have to deal under the Indian Contract Act 1872 only. So I'm going to share my screen now. I hope everyone can view the same. Okay, so we are going to start with the Indian Contract Act 1872. When it comes to Indian Contract Act, we all know that this is one topic which comes under the business legislation part. And business legislation means what? That the rules and regulations which allow us to understand that how to deal the business when it comes to dealing in the adherence of rules and regulations. So there are many acts which allow to understand that how to deal day-to-day activities in the business relevant to the statutory provisions. So that's why this paper is important. The Indian Contract Act 1872. Contract, we need to understand the meaning of contract, that what the contract is, how the contract established between the parties, what are the mode of discharges of contract, and what are the remedies if anyone have breached the contract. So basically this Contract Act was enacted on 1st day of September 1872. And yes, it is applied to whole of India except the state of Jammu and Kashmir. There were 266 sections under the Indian Contract Act 1872, but further it was being bifurcated under four categories. The first is section 1 to 75, where you can find the general principles of law of contract. In 76 to 124, you can find the contract related to sale of goods. In section 125 to 238, you can find the special kinds of contract, and in section 239 to 266, contract related to partnership. Now, topics which we have discussed under this particular chapter: the definitions, essential elements, types of contract, special kinds of contract like bailment, pledge, indemnity, indemnifier, contingent contract, quasi contract, discharge of contract. Like there are two modes of discharge, one is based on performance and another is based non-performance. Then remedies for breach of contract. What does it mean? Like if any of the party is not fulfilling the obligation, then what remedies is before with another party. Now come to the introduction part, which we can deal under the definition. The simplest definition of contract is like an agreement enforceable by law is a contract. So basically the whole technicality lies under this enforceability of law. That what does it mean? Enforceability by law. So first we understand what does agreement means. Apart from the basic definition, first understand with an example that someone have asked another party to come to their home for a marriage purpose, like for a birthday party celebration. So on the basis of non-availability on the day, even we have consented. Like if someone have asked or invited someone to their home for a birthday party celebration, if one of the party have not visited, the another party don't sue the party. Reason being that this is a kind of social obligation. We do invite people. It is based on their preference that they will come, they will visit the place, they will not visit the place. In fact, there are many agreements we enter in our day-to-day life that are social agreement and that are social in nature. But when it comes to business contract which exists in business place, this is not a social kind of nature. Reason being that it creates an obligation before the party. Like if party will not perform, the another party have a remedy. Remedy means what? They have a solution. So contract means an agreement which is enforceable by law. So basically you can differentiate, like agreement means there are social kind of agreement. When it is enforceable by law, it is not a social kind of agreement. So basically, according to the Indian Contract Act 1872, an agreement enforceable by law is a contract, and it is mentioned under section 2H. Now, when it comes to an agreement, which can be defined as every promise and every set of promises forming for consideration, means there are two parties in a contract. One party is giving his or her consent on the basis of what another party has offered. So it becomes a promise, and if both parties are agree, then it becomes the set of promises. Forming the consideration means what? Price. There are many things if I give someone a watch, on the non-performance of the watch, another party cannot sue me. Reason being that this is a social kind of agreement. There are the parties who have received, but on the non-performance of the product, the another party cannot sue. But if I have purchased the same watch from a shop and for a price, then in the case on the non-performance of the product, I can sue the seller. Reason being that we have the rights and duties when we are entering in a marketplace for a contract of sale. So agreement is promise and set of promises forming the consideration for each other. Then acceptance and promise, which you can elaborate as when the person to whom the proposal is made. As I have said, one party will offer and another party will give his or her consent towards the aforesaid proposal. So offer in one hand and acceptance in another hand. Then it becomes a promise. Now, what you can see here with this help of this diagram, the basic of contract is that contract is an agreement which is enforceable by law, and here the all technicality lies when it comes to enforceability by law. There are some legal formalities which need to be fulfilled, then only an agreement can be enforceable by law. So this agreement will be made between the two parties. There must be at least two party where agreement is being made, like party A and party B. Here is party A and here is party B. One party, at least two party. So the contract can be made between the two parties. So between these two parties, what you can see, that one party will give his offer to another party and another party will give his acceptance for the aforesaid offer to the party in front. So A become party 1 here, that is called P1, and B become party 2 here. So what you can understand, like one party will give the offer before the another party and another party will give the acceptance for the aforesaid offer. Then it becomes the promise. And set of promises means what? That both parties are agree with the same terms and conditions. Then this agreement, then promise and set of promises becomes an agreement. An agreement enforceable by law is a contract. So what you can see here, like here the offer is, this offer will come this way, this offer will come this way. Here the promise and set of promises. Okay, then it becomes an agreement, and when an agreement will be enforceable by law, means all the terms and conditions, all the essential elements are present of a valid contract, then a contract is said to be contract. So for the development of the contract, there are two parties. The offer and acceptance must be exchanged between the parties. And this offer and acceptance, when exchanged, it becomes the promises, and then promises for consideration, then agreement, and then agreement enforceable by law is a contract. Why this agreement enforceable by law is contract? Reason being that when you are giving your acceptance to another party, that offer and acceptance create an obligation before the party, that whatsoever supposed to perform, you are obliged to perform. If you have taken admission in a course, you have to complete your course. This is an obligation before you. Whenever, if you have ordered some product to a marketplace, this is an obligation to pay the price before the party. So both party exchange the offer and acceptance, that create an obligation before the party. And when obligation is being created, parties are supposed to perform. Reason being that in case of non-performance or in case of failure, the another party have a remedy. The another party have a remedy means there are two sorts of parties. One which made an offer, another which made her acceptance. If you have went to a marketplace, or if you have went a restaurant, you have eaten the food, consumed the food, you have ordered, you have eaten, then this is an obligation before you that you have paid the price. So contract means what? This is a kind of an agreement which is enforceable by law. Enforceable by law means there are some of the essential elements which need to be fulfilled, then an agreement will be said as a contract, because it is enforceable by law. But where the enforceability by law is missing, like in social agreements, enforceability by law is missing. So an agreement cannot be said as a contract. So basics of contract I have narrated. Please go through this video and try to understand. If you don't understand, what you can do, just text me in the classroom that ma'am, these part you can elaborate again in the second lecture. I'll be just taking all this a recap in the video lecture. Thank you for the day.